Your Honors, the matter before the court this morning is the case entitled Imre Kurt Daims slash Brattleboro Common Sense, case number 23 AP 306. Appellant Kurt Daims and Brattleboro Common Sense are self-represented and appearing by WebEx. Representing the appellee, the town of Brattleboro, is attorney Robert M. Fisher.
Okay, thank you. Good morning again, everybody. Mr. Dimes, can you
Sir.
hear me, sir? Good. And I can hear you. You understand you have 5 minutes,
Yes, sir. I understand that.
and we'll give you an alert when you have about 1 minute left. Okay, so please go ahead.
Thank you, Your Honor. In this matter, BCS was upfront and studious. There were no permitting procedures that fit this brand new kind of emergency shelter. So we lobbied the town officers and committees thoroughly for a year before we had any RVs on our land. And then confusion set in. The zoning administrator, who told us not to let permits delay the project because it was an emergency, contradicts the select board, the local health board, who assented to one of their members denying that there even was a housing emergency in Vermont. The zoning laws contradicted the fact that we had a business license to have RVs on our land. The town was confused in ignoring the Superior Court decision, which said that our shelter was safe, and they began to indict us or prosecute us for having dangerous situation. There's more confusion everywhere. The Vermont Health Board and the local health board confused the local health officer with an expert, thinking that he had any expertise or professional qualifications, while the statutes actually require no training or expertise for him. The local health board, who had not studied evidence of quasi-judicial rules for the trial February 21st, which underlies this appeal, they were confused about their procedures, and when convening as, first convening as select board and then convening as health officers, health commissioners, they asked the attorney at that last moment for justification to reject our written defense document. Confusion also reigned between the town attorney, who maintained that the shelter was not a campground and was dangerous, and the zoning officer, who certified it as a safe camping site. The attorney forgot the difference between rhetoric and reality. Bob did. And he told the Vermont Health Board that BCS project was not unusual, and that the shelter was a hostage situation, and that I committed crimes against humanity. Once losing perspective on rhetoric and reality, people can lose the difference between right and wrong. There was a witness with a personal grudge who saw an outdated advertisement about rented shelter and entitled himself to present his suspicions as fact to the town officers. And he wrote that I collected $5,000 a month from the poor homeless people to whom we were giving shelter for free. And the town town officers shared that letter among themselves before the hearing, before my trial, without notice to me, and without mentioning this secret evidence at the hearing. They were very confused about their obligations under law. The health officer could not find any feces at our shelter. He walked the whole length of the property, and then he asked where was the feces, and then he reports, in his own words, as a scientician, that feces was everywhere. This man generally reported his suspicions about technical claims
Mr. Dimes,
without photographs.
Mr. Dimes, you have 1 minute left.
Thank you. Without photographs, measurements, or chemical testing. I understand the town attorney is obligated to jealous advocacy, but He went beyond the limits of legal and ethical standards. In their confusion, all this confusion, the town officers substituted suspicions for fact, and in their presentations, they substituted falsehoods for health. They are amateur bureaucrats with no legal acumen or inclination to cooperate among themselves. Thus, we have a faulty decision of the Vermont Health Board. Thank you. I
Okay.
have a couple seconds left. Let's reserve it for me.
All right. Thank you very much. We'll hear from counsel for the appellee. Counsel, please identify yourself and your client and then proceed.
May it please the court, my name is Robert Fisher. I represent the town of Brattleboro, the appellee in this matter. This matter is a matter that is appealed from the Vermont Department or Board of Health, and was an appeal of the local Board of Health decision and finding with regard to Mr. Dimes's RV project or homeless shelter project that he decided to build or create on his property without following either zoning laws, which is another appeal that's already been dealt with, or in complying with either the town ordinances with regard to health and sanitation, rental housing codes, and or fire protection codes. So in the de novo hearings, there were 2 hearings before the Board of Health. The town presented its evidence in chief during the first hearing, and Mr. Daims was able to cross-examine. Mr. Daims was afforded a second hearing, and he called 7 witnesses. The board listened to his witnesses, did indeed tell Mr. Daims to move on from the issue of the feces, which he was arguing was dog feces, and which the town had originally noted feces on the lawn of the property with toilet paper in it. But that really was a non sequitur when we got to the hearings before the Board of Health. The Board of Health matters dealt more with the fire prevention codes, rental housing codes, and the local ordinance. And the standard being whether the facts support the findings. Unless Mr. Daims can show that those findings are clearly erroneous, the town maintains that the Board of Health's order should stand in this matter. Mr. Daims also raises the issue that the hearing officer, retired Judge Belcher, was the improper person to make the ruling on whether or not to reopen the evidence so that Mr. Daims could try to put into evidence his exhibits, which were denied at the end of the second hearing, as they were not authenticated by any of his witnesses and were ruled inadmissible. Mr. Daims filed that only after the town had proposed its findings to the Board of Health, and after the hearing, the second hearing, July 11th, had been closed by the hearing officer and the board. So that rule to which Mr. Daims cites is applicable because the hearing had concluded at that time, and the town maintains that that rule is not applicable. And even if the court were to consider it, the town maintains that it is harmless error insofar as it does not offend substantial justice or rights of the parties in this matter. So for those reasons, Your Honors, the appellate town of Brattleboro requests that you affirm the decision of the Vermont Board of Health in this matter.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 14 seconds remaining.
All right, Mr. Daims.
Sure. We were very clear. We were the only people that were clear as to how unclear the laws were, sir, Your Honors.
Okay.
And thank you.
All right. Well, thank you. Thank you both. Please call a conclusion.